I'm very, very pleased to chair this panel where we are going to explain the new project that has been initiated this year by ELI. It's a project on guiding principle and model rules on algorithmic contract, and we will discuss what is exactly the meaning of this term and why we have decided to use it, what is the purpose, and what's more important, what is the scope of the project and the aims. It's a project that has 5 co-reporters, so I would like just to mention, because not all of them are today in the panel, just for logistic purposes, as you can imagine. So the co-reporters are Mari-Jules Sorensen in front of us, Christian Twig-Flesner in the hospital, Dariusz Schostek, he could not come today, unfortunately, Christoph Busch, and myself. So this project comes from the innovation paper on guiding principle for automated decision making that was presented to the ELI and was adopted this year as well. And I'm very proud and happy to say that I was the author, and I was very happy to receive such a positive feedback and useful input from all the ELI members that decided to contribute. And taking that as an inspiration, this project tried to go further and try to discuss, explore. I will discuss in a minute exactly what are the different approaches, but try to explore and discuss and assess the adequacy of existing contract law, and in particular in one of the deliverable, the consumer protection law, when we used algorithmic systems or autonomous system, that means artificial intelligence driven system, throughout, within and throughout the contract life cycle. So as we are going to explain in a minute, essentially the idea is to take this idea of automated decision making. Automatic include algorithmic, so purely deterministic algorithmic system, as well as autonomous system, those that incorporate machine learning, deep learning, and other techniques that include a level of autonomy in the context, fully or partially, of a transactional context. So could be in the negotiation, could be for the purpose of concluding the contract, could be in the performance phase, or could be in the enforcement, and therefore triggered by a default of one of the parties. So this is essentially the idea. And taking this idea in mind, and if I may just have, please, the presentation available. It's not yet in the main screen. Okay, it's going to be in a minute. It takes a couple of minutes, but it's going to be available. Okay. So as you can see, the idea is to go throughout the entire contract life cycle, taking into account the impact of algorithmic system in one or several phases of this life cycle. And I insist on this idea, taking into account as well the additional complexities that artificial intelligence-driven system add to the initial problem of automated decision-making based on deterministic algorithm. Taking that into account, what we are planning to do is work on 2 different main outcomes. I will show you in a minute what is the timeline, but as you can see, we are going to work first from 2 perspectives. The group has been divided in 2 different subgroups. One of the group that is led by Christoph, and he will explain in a minute, is essentially a group that is observing the market, is trying to understand what are the scenarios, what are the use cases where algorithmic systems can be applied in the context of a transactional situation, any of the phases. So essentially is to understand and create scenarios in order to test the existing rules and see how they work or what are the gaps that we want to fill. The other subgroup that I'm essentially leading or coordinating is more, in a way, future forward, and is trying to be creative, imagine, formulating, and devising guiding principle in order to guarantee that those gaps or inadequacies that we are going to probably find out in our analysis could be properly solved, could properly start out thanks to this principle and future model rules. You will see as well that these two perspectives take into account both business to consumer situation as well as business to business, peer-to-peer, and M2M transaction as well. So guiding principle, creative work, perspective work, and use cases and scenarios, observing, exploring, understanding the reality. With this methodology, with the twofold methodology, we are planning to produce two main outcomes. On the one hand, and this is an interim report that is going to be the first one to be on the market, is what we called an ADM readiness test of the European Consumer Protection legal framework. Christoph will explain later in more detail what are we planning to do with this, but as you can see, it's essentially to take what we already have, so the rules that we already have in the European Union legal environment, and see to which extent these rules are properly embracing the possibilities, the problems, the complexities that algorithmic contract, as I explained before, entail. This is the first one, and we are planning to have that report in 2023. The second deliverable, as you can see, is 2023-2024 is the second deliverable, is essentially a more prescriptive outcome, in the sense that we are going to develop, elaborate this guiding principle and model rules that I mentioned before. So once we have tested to which extent the legal framework is working properly or not, we're going to identify gaps, we're going to identify inadequacies, we're going to identify point of friction, and the idea is to solve it with a set of guiding principles and model rules where it is necessary. So what we're going to do today, and you can see what is the time scale if you would like to know what are going to be our next step. What we are going to do today is we're going to explain in a little bit more of detail what we have done so far in the guiding principle groups. And I would like to discuss with you the first deliverable that we have already achieved, in order to see to which extent you find it adequate, well focused, and it's definitely a work in progress, but we would like to test with you. And then Christoph is going to explain the work, the progress that has been done in elaborating, creating, and drafting use cases and scenarios. Immediately after that, I will have the pleasure to give the floor to Gisela Finocchiaro, because she, as a chairperson of the UNCITRAL Working Group on electronic commerce, but in particular in relation to the project of AI and automation in international trade, she's going to explain us what is the scope of this project, to which extent we are working on a similar scenario, a similar territory, and how we can coordinate properly our work. Finally, I will give the floor to Maria Peltoniemi, Policy Officer from the European Commission, DG Just, and we will have, therefore, the European Commission perspective on the need of this project and how this project can contribute. So please let me explain you what are we doing so far, what kind of problems we want to solve, what kind of issues we have found out, and how we are trying to solve them with the formulation of certain principles. So this is the scenario that we have taken into account in the guiding principle group. As Christoph will explain later, this is the scenario that we call, in this idea of having different level of automation, this is the scenario that we call full automation. It's a situation, as you can see, where we have a consumer. We are now, remember, in the first stage, so business to consumer, in order to prepare the ADM readiness test for the European Commission idea, for example. So we have a consumer, and this consumer rely on what we could call algorithmic delegate, algorithmic agent, for the purpose of concluding on a systematic and regular basis contract in his or her name and on his or her behalf. So as you can see, we have, for example, a smart fridge. This smart fridge is programmed to, on a regular basis, on weekly basis, for instance, to do the shopping for the consumer. And this shopping, this purchase, is going to be based on a set of criteria. Could be, for example, connected to my calendar. and therefore the smart fridge is going to know whether I'm planning to be at home or traveling next week. So probably the shopping is going to be more or less limited depending on that. It's going to confirm the information provided by the sensor of the smart fridge about the expiration date of the product that I have and how many products I have stored at home. And it's going to take a decision. And it's going to do the shopping for me. And this shopping, this transaction, is going to be concluded directly by the algorithmic agent with third parties. That could be the supermarket. But the consumer is going to be the one legally bound by this transaction concluded in his name and on his behalf by the algorithmic agent. So we have this triangle situation that we want to open and explain properly. And then we have other actors involved in the process that, as I will explain in a minute, may be subject to certain duties. The operator, so the one who has control and is benefited from this smart fridge, but also the vendor of the smart fridge, and maybe the provider of data that enable this smart fridge to conclude the transaction properly. So this is the scenario that we use, and this is our first and completely ongoing analysis. So we have decided first to start by definition. And this is indeed a huge and complicated task for two reasons. First, because we don't want to define in a way that we are not technological neutral, and this is always a problem that we have to face. And second, that in the definition, we might face the problem of using terminology that has legal implication. And we want to be sure to which extent we want that implication of the terminology that we use. For instance, and we will explain that in a minute, for instance, if I use the word algorithmic agent, are we assuming that the relationship between the consumer and this smart fridge is a principal-agent relationship? Are we going to apply the agency law to all the different legal effects surrounding this relationship or arising from this relationship? Is a good idea? Is a sensible idea to call them agent? Can we really consider agent that is not human-based third party? Can we use that term for where we know that is not a human being acting with this level of autonomy and freedom that we assume a human being has? So to which extent using this terminology is indeed a problem, or we should avoid it completely and try to be creative in the use of new terms? But avoiding this first problem that is conceptual and is very important, we have decided to define this smart fridge, this algorithmic agent as a system that is algorithmic system, AI-driven system that conclude transaction in the name and on behalf of the consumer without requiring consent by the consumer in every transaction that this smart fridge is carried out. So this is the level of automation that we need. The level of automation that we need is that each transaction is concluded automatically by the smart fridge without requiring explicit consent of the consumer. But of course, we need to guarantee that there is a connection in order to ensure the allocation of legal effect. And in order to do that, I will explain you in a minute, we have designed a presumption based on, naturally, a prior consent of the consumer to be bought in the future by the smart fridge that is taking decision in his name and on his behalf. So this is the definition. Then we have formulated for the discussion here, and therefore for being refined and elaborate in the future, 4 different principles. The first one, that is the most important one, is what we call a rebuttable presumption. So how to create this connection? Let me use again this super controversial idea of principal agent. How do we create this connection of principal agent? We have designed, elaborate a rebuttable presumption based on 2 main components. The first one is the explicit consent of the consumer to be bound to be the principal, to be bound by this algorithmic agent in the future transaction. So we need to guarantee that the consumer knows, is aware, and indeed express the consent to be bound by the smart fridge. And second, in order to guarantee that this consent is free, is informed, is conscious, we have to guarantee that certain principles are properly complied with in the process. And these are principle 2, principle 3, and principle 4. So the idea essentially is, to the extent that these principles have been met, if the consumer has consented to be bound, is going to be bound in the future. So all the legal effects arising from the contract are going to be allocated, attributed to the consumer. In other words, the consumer cannot repudiate to be bound as a contracting party in any future transaction that the smart fridge has completed, unless the consent has not been given or the principle that we are going to explain in a minute have not been bent properly. This is our first and fundamental principle. What are the other principles that we consider absolutely essential to guarantee that this attribution of legal effect is protecting properly the consumer? The principle number 2, I would say elaborate, because Christoph is going to explain to which extent this duty to inform could be already embedded in the existing consumer protection law, or is something new. We will discuss that later if you wish. So we have a duty to inform. A duty to inform. The consumer has to be informed in advance that this particular smart product is going to conclude transaction to which he's going to be bound. So a prior information is fundamental. And this is fundamental because it could happen that I rent an apartment, I arrive to the apartment, and suddenly I discovered that the fridge is smart and the coffee maker is smart as well. And I suddenly be bound by transaction that I didn't know that these two smart products were concluded in my name and on my behalf. So this information that transactions are going to be conducted on an automated basis in my name is fundamental. Second, what kind of information I need to know that this is a smart fridge, first, and second, that this smart fridge is concluding transaction in conformity or pursuant to the following criteria: your calendar, your list of preferences, your prior transaction, and other like-minded people purchases. I need to know these criteria, and I should have the possibility to modify these criteria if I wish. For example, I don't want that my calendar is available for the purpose of future transaction. The third problem within this principle is who. Who should provide this transaction? Because I buy the smart fridge in a shopping mall, and probably the smart fridge is smart because there is a particular functionality embedded in the product that has been developed by a developer located in a completely different country. So who has the duty to inform? We consider that the center of gravity should be the operator. And the operator, Christiane, is the same idea that we use in our expert group on liability and new technologies. The operator is the one who has control over this algorithmic agent system and benefited from the operation of that particular functionality. Might be the manufacturer of the fridge, or might be a third party that is simply the developer of that particular functionality. But in order to make this more easier in practice, in many cases, the one who is going to be face-to-face to the consumer and in a better position to provide this information is going to be maybe the lessor or maybe the vendor of the smart fridge. So we consider that in addition to the operator, this other actor should also provide information to the consumer. Let me just go very quickly to principle 3 and 4, and I give you the floor in a minute. Principle 3 is a principle that has to be definitely reflect on further, but we think that is very important. To which extent we want consumer to be bound forever to a smart fridge? So to which extent we believe that this idea of being bound forever to any future transaction adopted by this smart fridge that I have at home? Should we elaborate, should we acknowledge a right to deactivate, a right to disable the autonomous functionality of the smart fridge? We think that that should be a right to be included in the legal framework, a right to deactivate. And this right to deactivate, that I'm not going to explain in detail, should not be provided in a way that in practice is impractical or unfeasible or so tedious and onerous that the consumer is not going to exercise. For example, if I deactivate the functionality of my coffee machine, the coffee machine is not making coffee anymore. So I'm indeed losing the main functionality of the coffee machine. What I'm going to do, probably assert that the coffee machine is smart and has to be smart forever. So we want to avoid this kind of situation that might be abusive. And finally, where we believe that is a necessary balance with this idea of attribution of legal effect, so we assume that I have given the consent, the consumer is going to be bound systematically in the future to any transaction, has to be balanced properly with Principle 4. There is a right to object and a specific transaction. So I know that my smart fridge is going to do the shopping every week. And I'm going to be informed, as usual, I'm doing the shopping, this is the list. But in a particular week that I have family at home, I am going out for the weekend, I want to object that particular transaction because it's too expensive, because I don't want this kind of product, because I don't need it. So we combine this idea of general consent with a right to object a specific transaction. So this is the first part of the project. As you can see, we are working in parallel. We have created this guiding principle, and at the same time, and Christoph is going to explain in a minute the progress of the group, the other part of the group is working on understanding what are the existing or the future scenarios. So please, I give you the floor. As you know very well, Christoph Busch is a professor of law at the University of Osnabrück. He's affiliated fellow of the Yale Information Society project at Yale Law School and co-reporter of these projects. Christoph, please, you have the floor.
Yeah, thank you very much. Following up on what Teresa has just explained, I would like to say a few words on the ADM readiness test that we are currently conducting. And as Teresa said, this is the first phase of the project, and it focuses on consumer law, and it focuses on existing EU consumer law rules. And the research question, in a sense, that we are trying to tackle is, does EU consumer law provide a suitable framework for the use of ADM systems, algorithmic decision-making systems, in contractual relations? Now, when we say suitable, that could mean several things. We are starting from the premise that contract law, consumer law serves several functions. One function could be described as the enabling function or the infrastructural function. So one aspect that we're looking into is, do the existing consumer law rules enable new business models that are based on the use of ADM systems? Or is consumer law a barrier to innovation in this sense? So that's the enabling function, in a sense. But then, of course, when we talk about consumer law, there is also the protective function. So a suitable framework should provide adequate protection to consumers in scenarios where ADM systems are used. So starting from this question, we are looking into a selection of EU legal instruments. We're focusing on 5 directives and a proposal: the Unfair Commercial Practices Directive, the Unfair Contract Terms Directive, the Digital Content Directive, the new Consumer Sales Directive, and the Consumer Rights Directive, plus the very new proposal for digital, for distance marketing of financial services from May this year, which contains some very interesting innovative elements that are relevant with regard to ADM systems. And we're looking at these texts and we're asking ourselves, where in these texts, which provisions work well with ADM systems, and where could problems occur, and where is a need for adaptation. Let me give you a few examples. Think of Article 9 of the e-commerce directive. We're also looking at the e-commerce directive. I should add this. And Article 9 of the e-commerce directive essentially says, member states shall ensure that their legal system allows contracts to be concluded by electronic means, and they shall not deprive electronic contracts of legal effectiveness and validity simply because they are electronic contracts. To us, this seems self-evident today, but 20 years ago, it was necessary to say that. Maybe today, it is necessary to state a principle of legal recognition for algorithmic contracts, where on one side, or maybe even on both sides of the transaction, not human beings are making a contractual decision. Of course, there's a legal attribution to a person somewhere, but the decision is maybe not made by a human actor. And maybe it's necessary to say that such contracts shall be recognized. But then the e-commerce directive not only stipulates this principle of legal recognition, it also adds some safeguards. Article 10. It requires a business that uses electronic means for concluding contracts to provide information about the technical steps towards the conclusion, about means to identify errors and to correct errors. Now, how would you apply these rules in a scenario where not a human is making the decision, but a machine is making the decision? Do you have to explain to the machine how the contract is concluded? Do you give the machine a possibility to correct an error? Probably not. So it seems that the e-commerce directive does not provide rules on defects of consent, but seems to provide rules that try to avoid errors in the first place. Now, maybe we need something like that for algorithmic scenarios. There are other points where emerging business models might clash with EU consumer law. And one obvious area is information duties. There are lots of information duties in the EU consumer acquis that serve, at least in theory, to ensure an informed decision. But if the contractual decision is made by a machine, is it necessary to provide information in plain and intelligible language? What does that mean? Would it have to be machine readable? Well, probably, but maybe it's not just a question of form, maybe it's also a question of content, of amount. Do machines need less information? Are they able to process even more information? So do machines solve the problem of the information overload? We're looking into this. I think the information paradigm of EU consumer law needs to be readjusted in the light of algorithmic contracting. There are other issues that we're looking into. How to ensure that a virtual assistant, but we're not just looking at smart fridges, we are also looking at virtual assistants, digital butlers, you might say. How to ensure that they are taking decisions in the best interest of the consumer, whatever that may be, but not in the best interest of the operator of the system or of a third party, a seller. How to ensure this? Is it necessary to stipulate a duty of loyalty for operators of such systems? And then, finally, are there limits to the use of algorithmic systems in consumer transactions? And interestingly, this very new proposal of May 22 seems to set some limits. There's a provision in this distance marketing of financial services proposal which gives consumers a right to speak to a human being when the business is using a chatbot or a robo-advisor. Is that first of all, is that a good idea? Because that could limit automation in a sense. And is that a principle that could be generalized beyond financial services and could be a more general principle of algorithmic consumer law, in a sense? So we're looking at these questions, and to give our work a more practical flavor, we're not just looking at the text, doing a close reading of the text and asking questions, but we are developing scenarios as test cases, little cases, hypotheticals, you might call them, where we try, and that's a difficult part of the project because it's a bit of legal futurology, because we're trying to look at use cases, at emerging business models that are not yet exactly there in the market, but that that are about to emerge. We are consulting with people who know a bit more about the market than we the lawyers do, just to make sure that our scenarios are not outlandish and that we are not totally off the track. But that's an interesting and somehow creative part of this project, to think about possible business models. And we're categorizing them into several groups: initiation of a purchasing process by ADM systems, automation of the negotiation phase, up to a point where the virtual assistant takes over the entire purchasing process. And so we are distinguishing between scenarios where algorithmic systems are used as a decision support system, where humans are still in the driver's seat and making the decision, but being supported by ADM systems. We call this augmented consumers, because the, let's say, capacity of consumers to process information is augmented in a sense. And then there are scenarios where human decision making is totally bypassed, and that we call algorithmic consumers. And this partial and total automation could happen on both sides of the transaction, on the business side and on the consumer side. And if you put this together, you end up with a matrix like this one, where you have several levels of automation. Partial automation by one party, partial automation by both parties, full automation by one party, full automation by both parties. Well, maybe this model needs further refinement, but we are trying to distinguish between different levels of automation. And a source of inspiration for this work is something that you probably know: the different levels of driving automation that for self-driving cars that have been developed by the Society of Automotive Engineers, where you also have, let's say, driving assistance up to total autonomous driving. And we think that it might be helpful to structure the debate and also to assess the ADM readiness of EU consumer law to distinguish between different levels of automation in the contracting process. Maybe that could also be a contribution of the ELI to the legal community to help to structure the policy debate and also the scholarly debate. So that's what we're doing in phase one. It's challenging and it's interesting, and I'm happy to be part of that team. Thank you.
Thank you, Christoph, very much. This project, as you can imagine, is greatly benefited by the project team members, the assessors, the advisors that we have, and we are learning a lot from them and trying to ensure that this approach is indeed the right one, is correct, and makes sense from a business and technological point of view. Now, we would like to test and to put in context this ELI project in the European context, and subsequently in the international context when we will talk about UNCITRAL project. So please, Maria Peltoniemi, may I give you please the floor, and you can give your feedback and your perspective from the European Commission. Please, Maria, you have the floor.
Yes, thank you very much, first of all, for the invitation to speak in this distinguished panel. I very much enjoyed listening to previous interventions and definitely many messages to already take back to my institution. I'm also very sorry that I'm not there as in person. That would have been probably even more delightful, but following from online then. Indeed, I'm representing the European Commission, and as my head of unit, Dirk Staudemeyer, who had a presentation in the previous panel on blockchain and smart contracts, he sort of started with emphasizing the importance of new technologies in the context of civil law frameworks more generally, and I'm now continuing a little bit from where he left. So we think at the European Commission that this topic of algorithmic contracting is indeed really pertinent and important. And we are very pleased to act as an observer in this project. So we are very grateful for ELI on this possibility. So basically, one of the priorities of the European Commission, as you are most certainly aware, is to promote the digital economy and the digital transition. And as part of this bigger priority, we think that new technologies such as artificial intelligence might take a larger role also in private law and in contracting in the future. So basically, we are very much interested in the same topic as ELI is. So basically, AI-enabled autonomous contracting or algorithmic contracting, however you want to call it. And we plan to launch a project, a pilot project also on this topic. It would investigate novel forms of contracting in the digital economy, more specifically, indeed, this autonomous contracting. So we are aware indeed of UNCITRAL work, which I'm very happy to hear about also in the next presentation. And it's quite interesting that this topic is gaining interest both internationally and at EU level currently. We're very much following also UNCITRAL work in this regard. So indeed, what we think is that maybe automated actions, if one considers actions where predefined parameters are sort of for the algorithmic agent or whatever are taking the decision of entering into contract, but there is indeed the predefined parameter, this might more easily fall within the remit of current private law frameworks already. But we are also very interested in this autonomous element, which was already mentioned many times here. So when autonomous or computational agent or algorithmic agent, indeed, however you want to call it, concludes contracts on behalf of legal or natural persons without or with hardly any human intervention. And here we think, and indeed, that if this AI agent is self-thinking, self-learning, capable of also adapting its behavior to changes in circumstances, here we think that indeed many questions related to private law frameworks might arise even more pertinent. Indeed, the question of general conclusion, or like the element necessary for the conclusion of the contract in general, like the human will, which is usually needed for the conclusion of the contract. How is it there? How is it present? Is it there? Also the avoidance of the contract, indeed, like if we think about a consumer contract context, how can the consumer get out of this contract then? And indeed, like the attribution of legal effects in general. What we see is that these new contracting solutions using new technologies, such as algorithmic contracting, they can be a great benefit for businesses in the internal market. And in this context, we think it's important to investigate, well, firstly, obviously, if the current private law frameworks are fit for these situations, like if there are obstacles which completely prevent us from using or prevent businesses from using these solutions. This is very much similar to the problem-based approach I understand also ELI has. But then also I think, and we think that it's important to analyze a bit further, indeed, if the regulatory environment supports this kind of innovation. So even if not creating obstacles, is it that these frameworks are promoting the use of algorithmic contracting? One example of a rule like this could be, which was also briefly mentioned already, maybe the pre-contractual information in consumer context. So if one thinks about the purpose of this rule, well, firstly, one can think, how is this computational agent delivering this message to this human being? And are we then still thinking that the human behind this algorithmic agent should get the message? Is indeed the message machine readable and so on? But on the other hand, one can indeed think about the purpose of this kind of pre-contractual information obligation in general. Like traditionally, I think it is remedying the lack of equality of arms between the trader and the consumer with regard to information. But here, if we think about an AI, which is capable of gathering all the information in the world, basically, like, well, not maybe, but at least very rapidly go through the internet and get the information, maybe there is not such asymmetry of information between the consumer and the seller anymore if the consumer is using such an agent. But indeed, we very much agree with the approach chosen by ELI for this project. As we understand this sort of ADM readiness test in consumer law, this is the first phase, but we are very happy to see also that this will be extended to B2B relations, so business-to-business transactions, where actually many use cases might already exist, or at least more use cases most probably. So we very much welcome this horizontal approach of the project, we think it is the most beneficial. We see indeed that ELI is looking at this from the perspective of the whole contractual cycle, so not necessarily only the conclusion of the contract. And it's very interesting to indeed see then like what kind of considerations would be connected to the pre-contractual phase, the execution of the contract as well. Although it might really be that the most pertinent legal questions might arise indeed in this situation where the contract is concluded, where the legal effects are created. And indeed this question of like humans always remaining in control, this is a tricky one also when we look at the technologies, how far are the developments of the technologies able to go, but then again, are humans ever ready to give all the power? I doubt it, and I think we all can agree that it's not what we guessed would happen very soon, that machines would start taking all the decisions on behalf of us. Against this background, we think that this ELI's work in developing the conceptual framework, these guiding principles, modern rules, also legal taxonomy, this can be extremely useful for the legal community and also for us, for the European Commission, in our future considerations of this topic. Indeed, as we are looking at autonomous contracting ourselves via this project, this does not mean that we do not, we do not have any policy initiative planned yet. So this is purely exploratory initiative at this moment. But we think that at its best, this ELI project can bring a lot of added value for us. Like it actually works both directions. So basically, first of all, we can use the legal expertise of ELI, but then on the other hand, this ELI project can have a potential to serve European Commission in its future considerations of indeed possible policy developments in this area. So we very much look forward to working closely together with ELI on this project, and I thank you very much for your attention and pass on to the next speaker. Thank you.
Thank you very much, Maria. We are indeed delighted to know that from the perspective of the European Commission, this work is pertinent and at value, and is indeed part of the regulatory and the legislative debate and plans for the future in the European Union level. And indeed, it's extremely beneficial that we have you as an observer in the project. But also at an international level, there is an important attention to what are the challenges of algorithmic contract and the use of AI in international trade. And indeed, UNCITRAL is also observer of our project. So we have this privilege of having both of them together with UNIDROIT as fundamental institutional observers of our project. Gisela Finocchiaro, our chair in the working group UNCITRAL, she's going to explain us the situation of the project, the scope, and the progress. Please, Gisela.
Thank you very much. Thank you very much for the invitation. It's a pleasure for me being here. I'll try to explain what UNCITRAL has done so far and what is going to do in the future on the issue of contracting through artificial intelligence. Of course, as has been said before, the issue of contracting through artificial intelligence has to be considered from a global perspective. And as you know, many international organizations and many international fora are dealing with the issues. UNIDROIT is working on a similar project, and the UNCITRAL decided to start a new project on the use of artificial intelligence in contracting in the next session. So we will start our project in October in Vienna, and we have just concluded another project in July, which has been approved by the Commission on identity management. I think it can be useful for us to share a list of UNCITRAL adopted texts, because they will be relevant for our work in the future. UNCITRAL started in 1996 with the model law on electronic commerce. It was issued more than 25 years ago. And it dealt with a basic question: the legal value of electronic message, the legal value of an electronic document, time and place of dispatch and receipt of a data message, attribution, and so on. After that, in the following years, many other model law have been adopted. As you can see, the model law on electronic signature, the United Nations Convention on Electronic Communication, and recently the model law on the use and cross-border recognition of identity management and trust services. All this work that has been done in the past is relevant for the future work, for the work to be done in the future. In this text, Ancestral has always observed some fundamental principles. They are basically three: technological neutrality, non-discrimination principle, and functional approach. And probably this basic fundamental principle will be observed also in the future. Looking to the future and looking to the new project on the use of artificial intelligence in contracting, I think that we will follow three directions. The first one is the following. We at Ancestral, we have already dealt with some issues in previous Ancestral work. And we have already formulated some provisions which can be incorporated in a future test on contracting about through artificial intelligence. Some example. Legal recognition of data message is not going to change. Legal recognition of electronic contract. Admissibility of data message as an evidence. This legal requirement to be writing, legal requirement to be signed, these are provisions already formulated in the past that we can simply incorporate in a future test. Second direction. There are some issues we have already dealt with which need to be reformulated and adapted. So we need to consider the work we have done in the past and reformulate and adapt it to a new context. So this is the second direction to follow. And I can give you some example of this provision. For instance, reformulation of legal recognition rule, automated performance of contract, mistake in the output of automated system, and so on. And then, third direction, we have to deal with new issues and new problems. So we need to consider new issues, not considered yet, and to try to formulate new solutions. And in this third direction, it's important to establish a dialogue with other organizations as European Law Institute, dealing with same issues and same principle. For instance, the issues to be discussed are, you can see a list here, in some cases overlap what you have already presented in the interventions before my intervention. In some cases, the issues are the same, but we have to consider that the scope of ancestral work is limited to business transactions. So the part of the work dealing with consumer transaction will be not examined, considered by ancestral work. In some cases, the issues to be discussed are the same. Attribution, if I'm not wrong, is principle 1 or 2. Principle 1 of the project that you are dealing with. Disclosure information is principle 2. Of course, it has to be formulated in a different way. It will be pre-contractual information, information about the contract to be concluded, but the matter, the subject is the same. Matters relating to state of mind. If we start to talk about agents, and it's a very delicate and problematic issue, because, of course, it has to deal with the subjectivity of the application, and this, of course, is a controversial, very controversial issue. Then we have to, if we accept subjectivity of the application, we have to deal with matters relating to state of mind. If we don't, we have to reformulate existing rule on the state of mind for new application. Liability, this is the most controversial issue always. Always in an international context, whatever the subject, it doesn't matter, but always this is the most controversial issue. Remedies and identification of objects. Should we deal also with the identification of things? And differentiated treatment for artificial intelligence systems. This is a short list. Of course, it has to be extended, but it's the list of future work we are going to consider in UNCITRAL starting in autumn. Well, I think that it would be essential to have a dialogue on these issues, because of course we should try to produce provision which could be applied at a global level, and it would be essential to try to reach them with a general consensus. So I think that it would be very important to have a dialogue with the European Law Institute, and in particular, I hope to have a dialogue on this specific project. And once again, I thank you for allowing me to present what is going to be done. Thank you very much.
Thank you very much, Gisela. So may I say that the two projects seems to be complementary. The perspective and the consumer perspective in the ELI is not dealt with by the UNCITRAL due to the scope of the mandate of UNCITRAL. The methodology is the same. At UNCITRAL working group, we are as well testing the adequacy of the existing international instrument in the context of the ADM, automated decision making. In our project, we are testing the European Union acquis in the context of ADM. So I think that we are extraordinarily well coordinated in that regard, and the cooperation at an institutional level and at a personal one is always extremely fruitful and appreciated. So may I please just immediately open I'm happy to see many hands raised to open the discussion. May we please start from the very end, please, Katia, and if you are so kind to introduce yourself.
Thank you very much. Thank you for the great presentation. My name is Rita Šimon. I'm from the Czech Academic of Sciences. I have an urgent question because the AI capacities are much wider than human beings' capacities. And there were one issue what you did not raise, and it was the sustainability issue. And my question, how far, because you are creating new decision architecture, and we know the behavioral bias and the limitation of the consumer information capacities and so on. So I detected 4 issues where I would be very happy if the algorithmic agent would use some default rules for more sustainable products, more sustainable transportation of products, less consumption. So I would be happy if we are consuming only what we need, not what we want. And the last, how you would deal the failed delivery. Thank you.
Maybe we can, please go ahead. No, continue, please. Maybe we may collect some questions and we will address them. Thank you very much.
Thank you so much. My name is Manuel Alba. I'm a professor here at Carlos III University as well. Thank you very much for such interesting presentations in such interesting topic. I have a question. I was wondering whether you are considering for the different projects, or you have seen in practice any cases in which we should consider the machines, let's say the fridge, for instance, okay? Not the agent of the consumer, but the agent of vendors, service providers, entrepreneurs in general. And the reason is that I think it's sensible to assume that in the market there will be partnerships. I mean, partnerships in a contractual and business sense between the makers and controllers of these machines and, of course, vendors and service providers. In some cases, it's even clearer, I think. For example, I recently purchased an Alexa speaker thing only because my preteen kids pushed me to do that. And for me, this is like sleeping with the enemy. I mean, in other words, I think in good faith, as a consumer, that this thing is the agent of Amazon, not my agent. And of course, as I'm sure you perfectly know, this has a bearing on many things, such as, for example, when there's an offer, who does the offer when there's acceptance, and who does the acceptance when personal data is given to the controller, who has to give pre-contractual information, and when is it correctly given, and many other things, right? So yeah, I think this could be even contractually addressed in different alternative ways, and I'm sure that, of course, entrepreneurs will do as they want and find the most useful ways for them. And I think, for example, this idea of deeming these things as our agents, even though, of course, based on practice probably, I think it's a bit dangerous, so to put it. And of course, it has to be debated, but thank you so much for the
Gracias,
invitation.
Manuel. Another question, please, so we can... Katia, if you are so kind just to move the micro from the end to the first row. And
Could I have
please,
a
no,
question as well,
I didn't
please?
see you.
Okay.
Please,
Sorry,
apologies,
Sean
apologies.
Charlton, Recherche et Documentation de la Cour de Justice de l'Union Européenne. Thank you very much for the presentations. I was just wondering whether do we need to adapt the legal framework? Could we not simply automate its application? So, for instance, to think about information duties, surely we could manage to get enough data on previous contracts that we could then embed an algorithm that would then tell us, is this a sales contract? Is it a simple sales contract? Is it a sales contract with linked elements into it? Or is it a credit agreement, and so on and so on? And then also in relation to the requirement for clear and intelligible language, I mean, with the advances now in sort of machine translation, this could really sort of complete the internal market. I mean, at the moment, it clearly is still fragmented at a linguistic level. So clearly, if we also embedded our machine translation, which we're also working on the basis of algorithms, then we would potentially be closer to completing that internal market. But we will also somehow need to have a human intervention at some point, particularly with machine translation, because also having worked as a lawyer linguist in the past, we can get so far. You could then, get in a Finnish company as terms and conditions ready for an English-speaking consumer. Yes, that's probably going to go quite well. But then when it needs to go to, I don't know, a German consumer, and it passes potentially through English and so on, then we can really get into mistakes that at some point will require somebody at least to check. And I wonder how those sorts of things you would integrate into a legal framework. Thank you.
Thank you for the presentation. I'm Francisco de Elizalde from my university here in Spain. I had a question concerning Principle 2 of the duty to inform So Teresa, you gave an explanation of parameters that the device will take. We have to inform about the decisions or how the decision will be taken. So you said food history, calendars, etc. But my question is that would work well for a rule-based system, but we have here the problem of more sophisticated machine learning systems that operate with neural networks, and we have the issue there of explainability. Do we really know how the decisions are taken? And if we don't know, should we inform that to the consumer, saying, okay, we take this data, but in the end, there is a risk of darkness or lack of transparency in the decision itself? Thank you.
Thank you, Francisco. Gracias. Frederick, please.
Thank you so much indeed for this very interesting presentation and very deep one. I would like to ask about, because I was thinking a little bit a question which was posed here, who is a principal and who is the agent of whom, because your example with refrigerator, it is more resembles the situation of the doorstep selling than of the distance contracts in certain sense. If we are talking about the purpose of the instruments of the EU law, the doorstep selling was more focused always on making the choice happen, that I don't lose my choice through this, that somebody is coming with a product to my home, and I have still the market which operates. Here is the question whether we are, by this regulation, we are somehow enhancing the possibility of the business to deprive me of the market, so to limit my choice, and whether we have instruments in this which really prevent or re-establish the instrument which we have, of course, in much easier situation developed for doorstep selling, but I still have a choice after my refrigerator buys. Of course, the food is a special example because of right to withdraw and so on. But the main mechanism, and maybe this is much more important to have even for food, the kind of right to withdraw. So really to keep my choice, and of course here the danger of individual pricing, that I get my price and I cannot really compare it, and there is no system of comparing it. It may have very, very essential impact on the market and the market functioning. And I think we have to see it as a risk.
Thank you, Frederick. I have a last question, I think. No, two questions more. Could you please? Yes, sir.
I'm Eric Hirschhorn. I'm a lawyer from Washington, D.C., and I admit to being relatively unfamiliar with European Union law. But I'm curious as to how much of the technology and the law for this area is already in existence in the automated trading of securities, of which there's an enormous amount, and it's been going on for, there's a book on it that's quite good by, I think, Michael Lewis. And it seems to be, it works well except when it doesn't. Sometimes the machines get the wrong idea and suddenly the market is down 500 points because something triggered automated trading. Obviously, this is not going to be such a focused volume. I also have a use case to suggest to Christoph, if you're the one working on the use cases, which is the possibility of using this system for, in a sense, a consumer purchasing of futures. Okay, there's a drought in Colombia where they grow coffee. So you're offered the chance by the algorithm to buy coffee at today's price 2 months hence. You can accept it or reject it, and it fits into your legal framework. But that's another possible application of this kind of technology. Thank you.
Thank you very much. So we are collecting all these excellent questions. Thank you very much for all this input, feedback, and question. We are going to start, I don't know, maybe Christoph, would you like to start? Another one. Oh, yeah, I forgot. Sorry. And two more. Yeah. Okay.
Very quickly.
Forgot it. Sorry.
I'd like to expand a bit more on the fascinating issue of who is the agent of whom. So it could have sense, in your opinion, to conceive of the relationship between producer and consumer as the principal agent relationship mediated by an ADM system. And this could perhaps also answer one of the the issues raised by Frederick Zoll.
Thank you. And so maybe the last, if I'm not wrong, the last question. And Birgit, no.
Thank you so much. My name is Julia Suragov. I'm a lecturer in the University of Deusto. It was very interesting to hear all your inputs and your work. And I'm also thinking about a question that has been raised already of the role of the agent and what has been also already said by your colleagues about Amazon and similar tools. All the developments and all the tools that we see, they are produced obviously by the industry, and the industry, they want also to ensure the future and the access to the market. And if the fridge is acting as our agent, the fridge should be completely independent. But the fridge is being produced by Samsung, by LG, by Siemens, or by Miele, and so they are thinking obviously on somehow generate more income in the future, and for that they will try to find a solution with the market, probably with providers like Amazon or whatever. A clear example is Alexa. Alexa works the other way around. Alexa is the agent of Amazon in your house, listening to everything. No, it's a great tool, but it works exactly the opposite way around. And on the other side, I also see a problem with, obviously, but I guess that you will also tackle it, and there are also other works that are being carried out on that about competition law. Since once you have Internet of the Things, in each case, you have a gatekeeper problem, and it gets bigger and bigger, the smaller the spaces for other people to have access to you. Thank you so much.
Thank you very much. I give the floor to Christoph, but just to comment to the question, because it's within the scope of the subgroup that I lead. You are completely right that this idea of agent is not unidirectional. We have contemplated precisely the possibility that, depending of the business model, depending of the characteristic of the product, how it's programmed and what is the way of operating, could act indeed as an agent of the vendor. Sorry, I was trying to find the proper word. For example, it's very easy to imagine a Nespresso coffee machine that is indeed the agent of Nespresso at home, compared to a smart fridge that may, for example, consider different supermarket, different prices, and therefore is indeed, or could be considered my agent if we use this parallelism. And the second point is that many of the principle and the question that you have raised, they are contemplated at least in the guiding principle that I mentioned before, so the previous innovation paper. For example, this idea of responsible algorithm. So algorithm or sustainable algorithm that are designed in a way that promote these kind of positive values instead of create situation that we consider unresponsible or with a negative social impact. And we are going definitely to develop all these principles in a more detailed way, as I explained before with the 4 principles. That is just one part of the full project. But please, Christoph.
Yeah, I will probably not be able to respond to all questions, so maybe I'll leave some for Teresa, and I will choose the easy ones then. So first of all, thank you for raising the high-frequency financial algorithmic trading aspect. Indeed, this is already real. This is happening, and I think this is a pattern that we see in many fields that finance is driving the innovation, and that models that are being applied there are moving towards the broader market. So I think we will have to look into that definitely. Then sustainability, Rita Simon's point. I think that's a very interesting policy issue. Of course, it could be possible to embed public policy considerations into the machines, and that of course links to the broader debate about greening of consumer law. But I think that's a very sensitive issue, whether there should be, let's say, a mandatory requirement that the first option that the virtual assistant proposes is the most sustainable option, or that they should be presented more prominently than other options. That's a public policy issue that maybe that we should keep on our radar, but it probably goes a bit beyond what we are looking into. Then I think the very important issue is the fridge, or maybe I think maybe the first application will not be fridges. In the literature, we always hear about fridges. I personally think that this will be the place where the virtual assistants, where the algorithmic assistants will be. It will be an app that you download on your smart device, or maybe in your smart home or in your smart car. So a sort of not a physical thing, but more a software in a sense. But then indeed the question arises, is that my agent? Is it the agent of a seller? There could also be a third option, I think. It could be a sort of intermediary, similar to the platforms. Basically, Alexa could be conceptualized as a platform that matches buyers and sellers. And then I think we will come across a lot of the points that we discussed in the platform project again. We mentioned issues of duty of loyalty. There's a very interesting new paper, I think it's on SSRN, by Michal Gal from Haifa on voice assistants, and she raises the question whether there should be a sort of fiduciary duty of operators of voice assistants. I think we have to look into this. And then Friedrich Zoll said the widespread use of algorithmic assistants could change the way markets operate. I think that's a very important point. If there is a dominant provider of virtual assistants for consumers, this dominant provider could even lead to a scenario where we're moving a bit from a market economy to a sort of central planning economy, where this provider tells us what to buy, and it limits the options. And here again, there is the parallel to the platform economy. Just think of Amazon's choice that is offered when you ask Alexa. So I think there's also this market, not only the individual consumer protection issue, there's also the bigger, you might say, macro perspective. And there's, again, that's my final remark, a wonderful paper from Rory Van Loo from Boston. I think it's called Algorithmic Market Perfection, where he looks into what happens if thousands of virtual assistants decide, because they are running on the same algorithm, to switch, that consumers switch to a different energy provider. That could be a huge move in the market that could tip a market. So I think there's also this macro perspective there. Yeah.
Thank you, Christoph. Just one point, because I would like to give the floor for a final comment to Gisela and Maria. But Francisco, your question of explainability is an extremely challenging issue, and I am still reflecting on that. But in order to avoid a simple use of, a formalistic use of explainability, so has to be explainable, but what that means, why we need explainability, what happens if explainability become completely unfeasible at the very end because of the complexity of the technology. In the innovation paper, I decided to avoid that issue directly and to use two other ways, the traceability of a decision, and on the other side, the idea that decision cannot be unreasoned. So cannot be arbitrary simply based on the fact that because it's complex, because it's opaque, because it's based on machine learning, because I cannot explain the other party, the consumer, the affected person is completely unprotected, is defenseless because cannot understand and therefore cannot challenge a decision because apparently the decision is impossible to be explained properly. So for me, explainability, instead of being it's an aspiration, but we have to understand what is the purpose of explainability. For me, the purpose is guaranteed informed decision on the side of the affected person and ensure that there are proper ways for challenge decision. And therefore, we are not using this kind of complexity as an excuse for arbitrary and unfounded or unreasoned decision using algorithmic contracts. So that would be my way of approaching, and we will discuss how to do that in the context of the project. So if I may give the floor, Maria, Gisela, Maria first.
Yes.
Maria, you are so kind to add a final remark, if you wish.
Yes, thank you very much. So yeah, I think from our perspective, it is quite important to understand the market that exists at the moment. And for this, we are also very thankful for ELI and for the scenarios and use cases that you are also going to develop. And as I said, we will also launch a sort of a pilot project, and we are also aiming to look at the market reality. So if indeed, like in B2B or B2C context, these use cases already exist, and then indeed thankful for, thank you very much for very useful comments that the audience gave, like on the sustainability aspects, on the partnerships in the market and stuff like this, because I think that if we then find out now or later that actually there is a market for algorithmic contracting solutions, which start really being used a lot, then one needs to indeed think about maybe also not only private law, consumer law related aspects, but indeed maybe there could become some competition law related issues or stuff like that. Anyway, we very much look forward to cooperating with ELI on this also in the use case collection. And then after we know a little bit more about the market, it's also more easy to check whether the EU legal frameworks actually would require some adaptations. Thank you very much.
Thank you, Maria, very much. Just to note, there is a comment in the chat, well noted. It's just a comment, not a question, so I'm not going to address that question. And please, Gisela, you're so kind to conclude.
Three very short considerations. The first one, agency. We should be aware that we are using a metaphor, a fictio iuris. It's dangerous when we use it. We should be aware of the limits of the fictio we are using. And in some cases, it's simply a way of allocating risk. In other cases, it's a way of describe in a very synthetical manner the contractual content. But in any case, it's a metaphor. So my question for you is, are you sure that you want to use this metaphor? Second consideration. Second consideration is about human intervention. And once again, it's a question for you. We have read about human intervention in many documents, legal documents dealing with artificial intelligence, especially at the European level. When do we need the human intervention in artificial intelligence contracting and in smart contract? When we do need it? Because it's easy to say we need a human intervention. When? And what moment and why? Third consideration, the third consideration is about explainability. Once again, it's a principle very often mentioned in a European document. In some cases, it seems that it is not possible to explain in advance, ex ante, what an artificial intelligence system is going to do. It depends on the kind of artificial intelligence that you're going to use. In some cases, if you use the machine learning approach, you're not able to explain in advance because simply the logic on which the system is based is different from the human logic. So it learns from experience and it learns from the past, so you are not able to imagine what it's going to do. If you cannot explain in advance, then it is more and more important to track the decision and to have evidence of the decision taken. So if you cannot use explainability, you have to compensate with traceability and evidence of what the system is going as decided, as done during this process. That's all.
Thank you, Gisela, very much. Thank you for all of you for this extraordinary debate, very enticing, thought-provoking, and very beneficial for our future project. Thank you very much, particularly to the speakers.